Appendix B. Answers to chapter review questions. The following appendix contains the answers to the individual review questions noted after each chapter. Chapter 1. Introduction to the Canadian Legal System 1. What are the key differences between rules and laws? Rules are guidelines specific to an institution or organization to regulate conduct and ensure smooth operation. They're often more flexible and adaptable. Conversely, laws are official regulations established by a governing body to govern behavior within a larger society. Laws are more rigid, universally applicable, and enforced by the legal system with penalties for noncompliance. 2. What is stare decisis and how does it impact the Canadian legal system? Stare decisis, meaning to stand by things decided, is a legal doctrine emphasizing the importance of following precedent. This ensures consistency, predictability, and stability within the legal system. By relying on past judgments, courts can maintain fairness and allow the law to evolve gradually. However, courts may deviate from precedent if a previous decision was flawed, the legal landscape has changed, or it no longer aligns with societal values. 3. What are the distinctive features of the two legal systems operating in Canada? Canada has a dual legal system. Firstly, there is the civil law system, which is based on French legal traditions and Roman law. The civil law system emphasizes comprehensive codes as the primary source of legal principles. Secondly, there is the common law system, which originates from English legal traditions. The common law system relies heavily on precedent and case law to interpret and apply the law. 4. How does the Canadian court system work? The Canadian court system is hierarchical and contains the following courts. 5. What is the burden of proof in civil and criminal cases? The burden of proof refers to the obligation to prove a claim. In criminal cases, the prosecution must prove the accused guilt beyond a reasonable doubt. In civil cases, the plaintiff must prove their case on a balance of probabilities. 6. What are the main steps involved in a civil lawsuit in Canada? 1. Determining the jurisdiction and figuring out which court has the authority to hear the case. 2. Parties exchange their pleadings, which are the written statements outlining their claims and defenses. 3. Parties undertake discovery by gathering evidence through document exchange and questioning under oath. 4. Following discovery is the trial, which the plaintiff presents their case, followed by the defendant, with witnesses and evidence presented. 5. The judge or jury will deliver a verdict, and the losing party may be responsible for legal costs. 6. Parties can choose to appeal the decision to a higher court if they believe the decision incorrect in fact or law. 7. What are the alternatives to litigation for resolving disputes? Alternative dispute resolution are methods help resolve disputes outside of court. The principal mechanisms are negotiation, mediation, and arbitration. Negotiation is where the parties communicate directly to find a mutually acceptable solution. This negotiation can sometimes lead to a settlement even before the pleadings have been filed. If the parties choose a mediation path, a neutral third party facilitates communication to help them reach a resolution. Finally, arbitration is when a neutral third party acts as a private judge, issues a binding decision that is difficult to appeal. 8. What is a limitation period and why is it important? A limitation period is a time limit for initiating legal proceedings. In BC, it's typically 2 years from the date a claim is discovered. Limitation periods encourage timely resolution of disputes and ensure evidence remains available. Failing to file within the limitation period usually bars the claim. Chapter 2. Canada's Constitution, the Supreme Law 1. What makes up Canada's Constitution and why is it important? Canada's Constitution is unique in that it is composed of 2 key documents, the Constitution Act and the Charter of Rights and Freedoms. Both elements of the Constitution represent the supreme law of Canada, and any law or government action which conflict with it is of no force or effect. This supremacy ensures the rule of law is upheld and that there is a check on government power. Another feature of the Constitution Act is that it outlines the framework for government, most notably the division of powers between federal and provincial governments in sections 91 and 92. The Charter of Rights and Freedoms guarantees fundamental rights and freedoms for all individuals in Canada. It provides protections over a wide array of personal freedom, including freedom of religion, expression, peaceful assembly, association, mobility, life, liberty, security of the personal, various legal rights, equality, and more. 2. How does Canada's federal system work in terms of lawmaking? Canada has a federalist structure with two levels of government, the federal government and provincial government, holding legislative power. Sections 91 and 92 of the Constitution Act speak to the division of powers by allocating specific areas of jurisdiction to each level. The federal government holds authority over areas of national importance such as criminal law, trade and commerce, national defense. The provincial governments have jurisdiction over matters of local concern such as health care, education, and property rights. 3. What is the Charter of Rights and Freedoms, and who does it protect? Enacted in 1982, the Charter primarily protects individuals from government actions that infringe upon their rights. While the Charter does not directly apply to private businesses or individuals, it does guarantee certain political, legal, and equality rights for all individuals against governmental action. Human rights legislation exists at the provincial level to address discrimination when it involves individuals or businesses. 4. Can the rights and freedoms guaranteed by the Charter ever be limited? Yes, the rights outlined in the Charter are not absolute. Section 1 of the Charter allows for reasonable limits on rights and freedoms if those limitations can be demonstrably justified in a free and democratic society. The Oakes test, established in R.V. Oakes, is used by the courts to determine if a limit on a charter right is deemed reasonable and justifiable under Section 1. 5. What are some examples of fundamental freedoms protected by Section 2 of the Charter? Section 2 of the Charter outlines fundamental freedoms, including the following. 2. Freedom of individuals have the right to practice their chosen religion without conscience and government interference, as demonstrated in R.V. Big M Drug Mart Limited. Religion, where the court struck down a law prohibiting Sunday shopping. 2. Freedom of this includes freedom of the press. However, this right is not absolute belief, as seen in R.V. Keegstra, where the court upheld the conviction of opinion and teacher for promoting hatred against an identifiable group. Expression 2. Freedom of individuals can gather peacefully for common purposes. Peaceful assembly 2. Freedom of individuals can join and participate in organizations of their choosing. Association including trade unions, as affirmed in Levine v. Ontario Public Service Employees Union. 6. How does Section 7 of the Charter protect the life, liberty, and security of the person? Section 7 safeguards individuals from arbitrary government actions that infringe on their life, liberty, or security. Section 7 has been instrumental in significant legal cases concerning medical assistance in dying and abortion. 7. What are some key rights protected by the Charter for individuals accused of crimes? The Charter provides several protections for those involvement with police or, more specifically, being detained and facing criminal charges. The idea behind the following rights is to ensure fairness during police investigation, detention, and the ultimate legal proceedings. 8. Other than S. 1. Does the Charter contain any other provision that allows governments to override some charter rights? Yes. Section 33, known as the Notwithstanding Clause, allows the federal or provincial governments to pass laws that may temporarily override certain charter rights for a period of up to 5 years. This clause, while controversial, aims to provide flexibility in policymaking while acknowledging potential conflicts between societal concerns and individual rights. FOUNDATIONSOFCANADIANBUSINESSL W297 Chapter 3. Tort Law in Canada Part 1. Intentional Torts 1. What is the difference between battery and assault in tort law? While often occurring together, battery and assault are distinct torts. Battery involves intentional, non-trivial, and offensive physical contact with the plaintiff. The contact must be unwanted, even if intended to be helpful, as demonstrated in Mallet v. Schulman, where a doctor performing a life-saving blood transfusion against a patient's religious beliefs was found liable. Assault, on the other hand, focuses on the apprehension of harm rather than contact itself. It requires an intentional threat of imminent, offensive contact from the tortfeasor, causing the victim to fear immediate harm. 2. Can an employer be held responsible for an employee's wrongful actions? Yes, under the principle of vicarious liability. According to vicarious liability, an employer can be held responsible for the torts committed by their employees during the course of their employment. This liability exists even if the employer was not directly involved in the wrongdoing. The landmark case of Basley v. Curry established that the scope of employment extends beyond explicitly authorized activities. In situations where an employee has power and authority over vulnerable individuals, unauthorized wrongful acts closely connected to their position can lead to vicarious liability for the employer. 3. What constitutes unreasonable interference in a nuisance claim? Not every disturbance will rise to the threshold of a legal nuisance. For a nuisance claim to work, the actions of the tortfeasor must be considered unreasonable. This unreasonableness determination hinges on a balance of factors. Firstly, the character of the neighborhood is considered, as there is a legal difference between a disturbance in a residential area versus an industrial zone. Secondly, the severity of the interference is examined, with minor inconveniences unlikely to be a nuisance while significant disruptions likely would. Thirdly, whether the defendant's activity is beneficial to the community would be considered. And finally, the law considers the overall sensitivity of the plaintiff versus a reasonable person. 4. How does the tort of intrusion upon seclusion protect privacy? Intrusion upon seclusion is a common law concept which safeguards privacy by addressing situations where someone intentionally intrudes upon another person's private affairs in a highly offensive manner. This intrusion can be physical, such as entering someone's home without permission, or non-physical, like intercepting private communications. The intrusion must be such that a reasonable person would find it highly offensive and causing distress. 5. Can someone be held liable for persuading another to break a contract? Yes. The tort of inducing breach of contract applies when someone knowingly and intentionally encourages a party to breach their contractual obligations to another. A successful claim requires proving 1. The existence of a contract, 2. The defendant's knowledge of the contract, 3. Their intention to cause a breach, 4. The actual inducement of the breach, and 5. Resulting damages to the plaintiff. The case of Drouillard v. Cogeco Cable Inc. serves as an example where Cogeco was found liable for inducing a breach of contract by pressuring Drouillard's employer, Mastech, to terminate his employment contract. 6. What is the difference between libel and slander? Both libel and slander fall under the tort of defamation that aims to protect a person's reputation from false and damaging statements. Libel refers to defamation in written form, such as newspaper articles or online posts. On the other hand, slander pertains to spoken defamation, including public speeches or even casual conversations. 7. What are the key elements required to establish a claim for malicious prosecution? To prove malicious prosecution, a plaintiff must demonstrate that 1. The defendant initiated a criminal proceeding against them. 2. The proceeding ended in the plaintiff's favor. 3. The defendant lacked reasonable and probable cause for initiating the prosecution. 4. The defendant acted out of malice or with a primary purpose other than upholding the law. Chapter 4. Tort Law in Canada Part 2. Unintentional Torts 1. What is negligence, and what are its key elements? Negligence is a legal concept in tort law that applies when a person acts carelessly, breaching their duty to take reasonable care, and causing harm to another. To prove negligence in court, 4 elements must be established. 2. What is the difference between professional negligence and product liability? Professional negligence is when someone with specialized skills or expertise, like a doctor or lawyer, breaches their duty of care. The standard of care is that of a reasonably competent professional in the same field, not just a reasonable person. On the other hand, products liability deals with injuries caused by defective products. In Canada, products liability is based on negligence, so the plaintiff must prove the manufacturer or seller was negligent in design, manufacturing, or warnings. Unlike the U.S. system of strict liability, simply proving a defect isn't enough in Canada. 3. Does the thin skull rule apply in Canadian negligence cases? Yes, the thin skull rule is a well-established principle in Canadian law. It means a defendant is liable for the full extent of a plaintiff's injuries, even if those injuries are more severe than expected due to a pre-existing vulnerability. Essentially, you take your victim as you find them. 4. What defenses can be raised against a negligence claim? Several defenses can reduce or eliminate liability in a negligence case. 1. Contributory negligence is where the plaintiff's own negligence contributed to their injuries. Damages can be reduced proportionally. 2. Assumption of risk is where the plaintiff knowingly and voluntarily assumed the risk of injury. The defendant may not be liable. 3. Statutory immunity applies when a law grants immunity from liability in specific situations, like Good Samaritan laws. 4. Illegality prohibits a plaintiff from seeking compensation for injuries suffered while engaged in a legal activity. 5. What is occupier's liability, and how does it differ from general negligence? Occupier's liability refers to the specific duty of care owed by those who control property to ensure the safety of people on their premises. It differs from general negligence in that it focuses on the relationship between a property owner and those who enter their property. 6. Are there different standards of care owed to different types of visitors on a property? Historically, Canadian common law distinguished between invitees, licensees, and trespassers, each with varying levels of duty owed. However, many provinces like British Columbia have enacted occupiers' liability acts to simplify this. These acts generally establish a single, broad standard of reasonable care owed to all persons entering a property, regardless of their status. 7. What is the rule in Rylands v. Fletcher, and does it apply in Canada? The rule in Rylands v. Fletcher establishes strict liability for damages caused by the escape of a dangerous thing from a property, even if the occupier wasn't negligent. This rule has been adopted in Canadian law and applies when an occupier brings something onto their land that is likely to cause harm if it escapes, even if they took precautions. 8. Does an occupier always owe a duty of care to someone injured on their property? Not necessarily. While occupiers owe a general duty of care, there are exceptions. For instance, under the British Columbia Occupiers Liability Act, an occupier has no duty of care to a person who willingly assumes the risk of injury, except to avoid intentionally causing harm or acting recklessly. Additionally, someone trespassing while committing a crime is deemed to have willingly assumed all risks. Chapter 5, Contract Law in Canada Part 1. Creating a Contract 1. What is the difference between an agreement and a contract? The key difference lies in enforceability. An agreement is a mutual understanding between two or more parties. It can be verbal, written, formal, or informal, and it may not be legally binding. A contract, on the other hand, is a legally binding agreement that creates obligations enforceable in court. 2. Does a contract need to be in writing to be enforceable? Contrary to popular belief, no. While written contracts are preferred for clarity and evidence, oral contracts can also be enforceable. The enforceability hinges on the presence of essential elements, not the form. However, proving the terms of oral contracts can be challenging. 3. What are the essential elements of a valid contract in Canada? 7 key elements constitute a valid and enforceable contract. 1. Offer. This is the clear proposal by one party to another, outlining the contract's terms. 2. Acceptance. The unconditional agreement to the offer's terms by the other party. 3. Consideration. Something of value exchanged between the parties. 4. Intention to create legal relations. A mutual understanding that the agreement is legally binding. 5. Capacity. Both parties must be legally capable of understanding and entering into the contract. 6. Consent. Both parties must give free and informed agreement to the contract terms without coercion or deception. 7. Legality. The contract's purpose must be legal and not violate any laws or public policy. 4. What are the different types of offers? The 2 main types of offers are called bilateral and unilateral. A bilateral offer is where both parties make promises to each other. For example, a job offer where the employer promises a salary and the employee promises work. A A unilateral offer is where one party makes a promise in exchange for the other party's performance of a specific act. For example, a reward offer for finding a lost pet. 5. What is consideration in a contract? Consideration is the something of value that each party exchanges in a contract. It can be money, goods, services, or even a promise to do or not do something. Crucially, the law doesn't require the consideration to be of equal value, just that something of value is exchanged. 6. What happens if one party lacks the mental capacity to contract? If a party lacks the mental capacity to understand the contract's nature and consequences due to mental illness, disability, or other conditions, the contract can be deemed unenforceable. The court assesses if the individual could understand the agreement and its effects. 7. Can I enforce a contract signed by a minor? Generally, contracts with minors are unenforceable against them. However, there are exceptions, such as contracts for necessities or if the minor affirms the contract upon reaching the age of majority. In British Columbia, additional rules apply under the Infants Act. 8. What is duress in contract law, and how does it affect enforceability? Duress involves forcing someone into a contract through threats, coercion, or pressure. It negates genuine consent. If proven, a contract made under duress can be voided. Examples include threats of physical harm or economic ruin. FOUNDATIONSOFCANADIANBUSINESSL W303 Chapter 6. Contract Law in Canada Part 2. Defective Contracts 1. What is a defective contract? A defective contract, much like a puzzle missing a piece, is an agreement where an essential element is absent or flawed. This defect renders the contract incomplete or invalid, preventing it from being legally binding and fully effective. 2. Can a statement made before signing a contract affect its validity? Yes, pre-contractual representations, although not terms within the contract itself, hold significant legal weight. False statements, termed misrepresentations, can lead to legal action. The consequences can range from awarding damages to the misled party to completely unwinding the contract, known as rescission. 3. What are the different types of misrepresentation and their implications? There are 3 types of misrepresentation. Firstly, there is innocent misrepresentation, which is a false statement made unknowingly and without intent to deceive. Even so, it can lead to contract rescission and damages. Secondly, is negligent misrepresentation, which is a false statement made by someone who should have known it was untrue and was intending to induce action. This can result in damages awarded to the misled party. Lastly, a fraudulent misrepresentation is a deliberate lie made with the clear intention to deceive, leading to detrimental reliance. A fraudulent misrepresentation has the most serious legal consequences, including damages, rescission, and potential criminal charges. What happens if both parties were mistaken about something in the contract? Mistakes in contracts can also render them defective. When both parties share the same fundamental misunderstanding, it's a common mistake, and the contract becomes void. If each party has a different misunderstanding about a key element, it's a mutual mistake, again voiding the contract due to a lack of true consensus. 5. Can a contract be voided if only one party was mistaken? Sometimes, yes. A unilateral mistake, where only one party is mistaken, can lead to the contract being voided, but only under specific circumstances. For instance, if the mistake involves the other party's identity and that identity was crucial to the agreement, the contract might be voided. 6. What is non-est factum, and when can it be used? Non-est factum, meaning this is not my deed, is a legal defense used when someone signed a contract without understanding its nature or terms. This defense applies if the signed document is radically different from what the signer believed, and if they were not careless in failing to understand it. 7. What makes a contract unconscionable? Unconscionability refers to a contract so one-sided or oppressive that it's deemed commercially, morally, or ethically unjust. This happens when there's an imbalance of bargaining power, and the resulting agreement is significantly unfair to the weaker party, making it unenforceable. 8. Can you provide an example of an unconscionable contract? The landmark case of Uber Technologies Inc. versus Heller provides a clear example. The SEC found Uber's contract clause, which forced drivers into a potentially costly and unfair arbitration process in the Netherlands, to be unconscionable and therefore unenforceable. This decision underscored the importance of fair access to legal remedies for all parties involved in a contract. Chapter 7, Contract Law in Canada, Part 3, Ending a Contract 1. How can contractual obligations be ended in Canada? Contractual obligations can end in several ways. 1. Performance where both parties fulfill their obligations. 2. Mutual agreement where the parties agree to end the contract. 3. Frustrating events where an unforeseen event makes performance impossible or radically different from what was agreed upon. 4. Breach of contract where one party fails to fulfill their obligations. 2. What is substantial performance in contract law? Substantial performance occurs when a party fulfills most of its contractual obligations with only minor deviations. While not perfect, the performance is sufficient to satisfy the contract's purpose. The non-breaching party may claim damages or a reduced payment for the deficiencies. 3. What are the different ways a contract can be ended by mutual agreement? Essentially, there are two ways this could occur, either through contractual terms or a new agreement. Firstly, contracts can include provisions outlining termination circumstances, such as options to terminate or condition clauses. On the new agreement front, parties can create a new agreement to discharge the original one. This can involve rescission, accord and satisfaction, variation, novation, release, or waiver. 4. What is the doctrine of frustration in contract law? The doctrine of frustration relieves parties from obligations when an unforeseen event makes performance impossible or radically different from the agreement. For frustration to apply, the event must occur after the contract's formation, be beyond the party's control, and render the contract fundamentally different. 5. How does a force majeure clause differ from the doctrine of frustration? While both address unforeseen events, force majeure clauses are contractual provisions, whereas frustration is a common law doctrine. Force majeure clauses allocate risk by outlining specific events that excuse performance, while frustration relies on a broader legal test. 6. What is a breach of contract and how does it happen? A breach of contract occurs when a party fails to fulfill its contractual obligations. This can happen through either anticipatory breach of defective performance. Anticipatory breach is when one party announces its intention not to perform before the due date. On the other hand, defective performance arises when one party performs inadequately or delivers substandard goods or services. 306 FOUNDATION SOF CAN AD IANBUS INESSL AW7. What are the different types of contractual terms, and how do they impact breach consequences? Conditions, warranties, and innominate terms are all forms of contractual terms, though they differ in significance to the contract. Firstly, conditions are the fundamental terms. A breach of a condition allows the non-breaching party to terminate the contract and claim damages or continue and claim damages. Secondly, warranties are less important terms. A breach of a warranty only allows for damages, but not contract termination. Lastly, innominate terms fall between conditions and warranties. The consequences of breaching an innominate term depend on the breach's seriousness. 8. How are contractual terms classified as conditions, warranties, or innominate terms? While there are varying ways to classify the contractual terms, there are also different mechanisms through which those classifications can arise. It's possible that specific statutes may define certain provisions as conditions. Additionally, court decisions can establish specific clauses as conditions. Of course, the parties can clearly identify a term as a condition in the contract. Lastly, the classification may also arise by implication. Based on the contract's nature, subject matter, and circumstances, a court may determine if a clause is significant enough to be a condition. FOUNDATION SOF CAN AD IANBUS INESSL W307 Chapter 8. The Sale of Goods 1. What is the Sale of Goods Act? The Sale of Goods Act is legislation that exists in all Canadian provinces and territories. The SGA sets out a series of rights and duties relating to the sale of goods, provides a legal framework for resolving disputes, and addresses the power imbalance between buyers and sellers. Essentially, the SGA protects buyers by establishing standards that goods must meet and by providing legal recourse if those standards are not met. 2. When does the SGA apply? The SGA applies to contracts for the sale of goods, which are defined as tangible, movable property. This includes items like vehicles, appliances, clothing, and furniture. The SGA does not apply to transactions involving money, services, or real estate. 3. What are implied terms? Implied terms are contractual terms that are not explicitly stated in a contract, but are automatically understood to be part of the agreement based on the SGA. These terms protect buyers by ensuring that goods meet certain standards. If a seller breaches an implied term, the buyer has the same legal rights as if the term was explicitly stated in the contract. 4. What is meant by sale by description? A sale by description occurs when buyer purchases goods based on a description provided by the seller. The SGA states that the goods must match the description provided, whether given orally or in writing. For instance, if a seller advertises a phone as the latest model but sends an older model, they have breached the implied term of description. 5. What are the implied conditions as to quality or fitness? The SGA outlines 3 implied conditions relating to the quality or fitness of goods: fitness for intended purpose, merchantable quality, and reasonable durability. Fitness for intended purpose means the goods must be suitable for the specific purpose communicated by the buyer to the seller. Merchantable quality essentially means the goods must be of acceptable quality and free from defects. Reasonable durability means the goods should last for a reasonable period considering their nature, price, intended use, and industry standards. 6. How is the passing of property determined? Passing of property refers to when ownership of the goods transfers from the seller to the buyer. The SGA provides 5 rules to determine this moment if it's not specified in the contract. These rules consider factors like whether the goods are in a deliverable state, if the seller needs to perform any actions before delivery, or if the goods are purchased on sale or return. 7. Can a seller override implied terms in a contract? Section 20 of the SGA states that any contractual term attempting to negate or diminish the conditions and warranties implied by Sections 17, 18, and 19 of the SGA will be void in retail transactions for goods not identified as used goods. This ensures that sellers cannot bypass the basic consumer protections offered by the SGA. 8. What remedies are available to buyers and sellers under the SGA? Buyers' remedies can include damages to compensate for financial losses, specific performance, and the right to reject or return non-conforming goods. Sellers' remedies include the right to sue for the price of delivered goods not paid for, liens, and stoppage in transit. Chapter 9, Business Structures 1. What are the main differences between a sole proprietorship, a partnership, and a corporation? The sole proprietorship is the simplest structure where the business owner and the business are one and the same. It's easy to set up with the owner having complete control, but it comes with unlimited liability, meaning personal assets are at risk. A partnership is where 2 or more individuals share the business's profits, losses, and responsibilities. Partnerships benefit from pooled resources and expertise, but may face unlimited liability. A corporation is a separate legal entity from its owners, offering limited liability protection to shareholders. It has a more complex structure, requiring incorporation and adherence to regulatory requirements, but it provides a shield against personal liability and allows for various ways to raise capital. 2. What is unlimited liability and why is it a concern? Unlimited liability means that the personal assets of the business owner are not separate from the business. If the business incurs debts or faces lawsuits, the owner's personal assets can be seized to cover those obligations. This is a significant risk for sole proprietorships and general partnerships. 3. What are the different types of partnerships in Canada? There are a variety of different types of partnerships, including the general partnership, limited partnership, and limited liability partnership. In a general partnership, all partners share in the business's operational management, profits, and liabilities. Each partner faces unlimited liability. A limited partnership involves both general and limited partners. General partners manage the business and have unlimited liability, while limited partners invest capital with liability limited to their investment. Lastly, a limited liability partnership offers limited liability protection to all partners for the partnership's debts and obligations, except for those arising from their own negligence or misconduct. LLPs are common among professionals like lawyers and accountants. 4. How does incorporating a business limit liability? When a business is incorporated, it becomes a separate legal person distinct from its owners and managers. This separation, often referred to as the corporate veil, protects the personal assets of shareholders and directors from business debts and lawsuits, limiting their liability. 5. What is piercing the corporate veil? And when might it happen? Piercing the corporate veil is a legal exception where a court disregards the separation between a corporation and its shareholders or directors, holding them personally liable. This typically occurs in cases of fraud, wrongful acts, or when the company is used as a mere extension of an individual's affairs, abusing the corporate structure. 6. What are the steps involved in incorporating a business in Canada? Incorporating federally or provincially typically involves the following steps. 1. A name search is conducted along with the reservation of an available business name with the appropriate corporate registry. 2. The articles of incorporation which outline the company's structure, rules, and regulations will be prepared and filed. 3. A physical or digital will need to be established as the registered and records offices to maintain corporate records. 4. The applicant will have to submit an incorporation application and pay the required fees. 5. After receiving a certificate of incorporation or notice of articles as proof of the corporation's legal existence, the corporation will be established. 7. What's the difference between federal and provincial incorporation? Incorporating federally allows the company to operate anywhere in Canada and provides greater name protection. On the other hand, provincial incorporation confines the company's operations to that specific province, but may offer lower incorporation costs and simpler regulatory requirements. The choice of federal versus provincial depends on factors like the business's scope, future expansion plans, and desired level of legal protection. 8. What are the key advantages of incorporating a business? There are a number of clear benefits to incorporating. Firstly, there is limited liability which protects personal assets from business debts and lawsuits. Secondly, the corporation continues even if owners change or pass away. Businesses are often perceived as more professional and trustworthy as opposed to operating as a sole proprietor. Lastly, businesses have access to a wider range of funding options and preferential tax treatment. Chapter 10, Employment Law 1. What is the difference between an employee and an independent contractor? While both employees and independent contractors provide services for compensation, the nature of their relationship with the hiring party differs significantly under Canadian law. Employees work under a contract of employment, meaning they are subject to the employer's control and direction in their day-to-day tasks. Key characteristics of an employee include ongoing service, typically with no fixed end date, and a relationship where the employer dictates the work process. Independent contractors, conversely, operate under a contract for service. They retain a high degree of autonomy in determining how and when they complete the work. Unlike employees, independent contractors typically manage their own taxes, insurance, and benefits. The distinction between these classifications hinges on the fourfold test, established in 6-4-9905 Ontario Ltd versus Sagas Industries Canada, such as 1. Does the hiring party dictate the worker's schedule, methods, or specific tasks? Greater control points towards an employment relationship. 2. Does the worker provide their own tools, or are these supplied by the hiring party? 3. Does the worker have the potential to make a profit or incur a loss based on their work, or do they receive a fixed wage regardless of outcome? 4. How integral is the worker's role to the hiring party's core business operations? 2. Do I have an employment contract even if I haven't signed a physical document? Yes, an employment contract can exist even without a formal written document. While it's advisable for both employers and employees to have a written contract, Verbal agreements or implied contracts based on conduct are also legally binding. The terms of an implied contract are inferred from the actions and expectations of both parties involved in the employment relationship. 3. What are restrictive covenants and are they enforceable? Restrictive covenants are clauses within an employment contract that limit an employee's actions after the employment relationship ends. Restrictive covenants come in three large categories. 1. Non-disclosure agreements that prevent the disclosure of confidential company information, such as trade secrets. 2. Non-solicitation clauses that prohibit former employees from soliciting clients or poaching employees from their former employer for a specific period. 3. Non-competition clauses that restrict employees from working for competitors or starting a competing business within a defined geographic area and time frame. The enforceability of restrictive covenants is principally determined based on its reasonableness. Restrictive covenants are heavily scrutinized to ensure they protect a legitimate business interest without being overly broad and unnecessarily restrictive on the employee's future opportunities. 4. What is a probationary period, and can I be terminated during this time? A probationary period is a trial period at the beginning of employment where the employer assesses the employee's suitability for the role. While probationary periods are common, they must be explicitly stated in the employment contract to be enforceable. During probation, employers have more latitude to terminate the employment relationship. However, even during probation, employers must adhere to minimum notice periods or pay in lieu of notice as mandated by provincial employment standards legislation. To enforce a probationary clause, courts will consider factors such as whether the employee was aware of the assessment criteria, whether the employer acted fairly, and whether the employee had a reasonable opportunity to demonstrate their suitability. 5. What is the difference between termination with cause and without cause? Termination with cause, or just cause, occurs when an employee is dismissed due to serious misconduct or a breach of contract. This is a high threshold for employers to meet. Examples of just cause might include theft, fraud, gross insubordination, or consistent and serious breaches of company policy. When terminated for cause, employees are generally not entitled to reasonable notice or severance pay. Termination without cause happens when an employer ends the employment relationship for reasons unrelated to the employee's conduct. This could be due to economic factors, restructuring, or a decision that the employee is not the right fit, even if they haven't done anything wrong. In these cases, employers are legally obligated to provide reasonable notice or pay in lieu of notice, as well as any accrued vacation pay. 6. How is reasonable notice determined in a without cause termination? In Canada, employees are generally entitled to reasonable notice when terminated without cause. 2 avenues determine this notice period. 1. Provincial employment standards legislation, where each province sets out minimum statutory notice requirements based on length of service. 2. Common law, where the courts may award a longer notice period than the statutory minimum based on the Bardal factors established in the landmark case Bardal versus Globe and Mail Limited. The Bardal factors include the employee's age, length of service, character of employment, and the availability of similar employment. 7. What is my duty to mitigate after being dismissed? Even if you believe you've been wrongfully dismissed, you have a legal duty to mitigate your damages. This means you must take reasonable steps to minimize your financial losses, such as actively searching for new employment. Failure to mitigate can reduce the compensation you're entitled to receive from your former employer. FOUNDATIONSOFCANADIANBUSI and ESSL, W313 Chapter 11. Intellectual property law. What is intellectual property law? IP law in Canada safeguards creations and innovations. It encompasses areas like inventions, designs, trademarks, and creative works. One of the principles of IP law is to grant creators exclusive rights over their creations, allowing them to control how their work is used and to profit from it. How does the Canadian government protect IP? Canada's IP law is a federal matter, meaning uniform laws and regulations apply across all provinces and territories. The federal government enforces IP rights through legislation like the Copyright Act, the Patent Act, and the Trademarks Act. These laws are administered by the Canadian Intellectual Property Office, ensuring consistent rules and enforcement mechanisms nationwide. What does copyright protect, and how long does it last? Copyright protects original literary, artistic, dramatic, or musical works. It grants creators exclusive rights to reproduce, distribute, perform, or display their work. Copyright protection in Canada is automatic upon the creation of an original work and typically lasts for the author's lifetime to the end of the calendar year of their death, plus an additional 70 years. What is fair dealing, and how does it relate to copyright? Fair dealing is an exception to copyright in Canada that allows individuals to use copyrighted material without permission from the copyright owner under specific circumstances. This exception ensures that copyright does not unduly restrict activities relating to education, research, or commentary. For example, using a limited portion of a copyrighted work for educational purposes may fall under fair dealing. What is a trademark, and why is registration beneficial? A trademark distinguishes goods or services from those of others using unique signs, symbols, or logos. Registration under the Trademarks Act provides significant advantages, including a presumption of ownership, national protection, and the right to use the symbol. It offers a stronger legal footing to prevent others from using similar marks and protect a brand. How long does trademark protection last? Trademark protection in Canada initially lasts for 10 years from the registration date. Unlike other forms of IP, trademarks can be renewed for consecutive 10-year periods indefinitely, as long as the renewal fees are paid. This indefinite renewal option allows for perpetual protection of valuable branding elements. What is a patent, and what can be patented in Canada? A patent is a time-limited right granting inventors exclusive control over their inventions. To be patentable in Canada, an invention must be new, useful, and non-obvious. However, not everything is patentable. Items like higher life forms, scientific principles, and abstract mathematical methods are excluded from patent protection. How long does patent protection last? A patent in Canada is generally valid for 20 years from the filing date of the patent application. After this period, the protection lapses, and the invention enters the public domain, meaning anyone can use it without permission. This trade-off between incentivizing innovation and eventual public access is a key characteristic of patent law. Chapter 12, Real Property Law 1. What is fee simple in real estate? The fee simple is the most comprehensive form of land ownership in Canada. It grants the owner exclusive rights to use, develop, and dispose of the property without a predetermined end date. This means the owner can sell, lease, or pass down the property to heirs. For instance, if you own a house in fee simple, you can live in it, rent it out, renovate it, or even demolish it, and you can decide who inherits it after your death. 2. What's the difference between joint tenancy and tenancy in common? Both joint tenancy and tenancy in common involve multiple individuals owning a property, but they differ in terms of survivorship rights and ownership shares. Under a joint tenancy, each tenant holds an equal, undivided interest with the right of survivorship. If one tenant dies, their share automatically passes to the surviving tenant, bypassing probate. With a tenancy in common, each tenant owns a specific share without the right of survivorship. Upon death, a tenant's share is distributed according to their will or inheritance laws. 3. What is a life estate? A life estate grants someone the right to use and occupy a property for the duration of their life. However, they cannot sell or dispose of the property. Upon the life tenant's death, the property reverts to the original owner or a designated beneficiary. 4. Can I acquire property without buying it? While rare, acquiring property without buying it is possible with adverse possession and expropriation. Adverse possession is where title is acquired by occupying and using another's property openly and continuously for a specific period without the owner's permission. In British Columbia, this has been largely eliminated by the Limitation Act. When expropriation occurs, the government takes private property for public use. This can occur when there is a compelling public project like building a highway or hospital. The original owner is entitled to fair compensation. 5. What are easements and restrictive covenants? An easement arises when someone grants the right to use another person's land for a specific purpose. Frequently, easements are in the form of rights-of-way to access property. Restrictive covenants, on the other hand, are a legally binding agreement that limits land use, often imposed by developers or communities to maintain specific standards. For example, a covenant might restrict building height or exterior color schemes. 6. Do my property rights extend above and below the ground? Yes, but with limitations. You have rights to the airspace above your land to the extent that you can reasonably use it, such as constructing buildings. However, these rights don't interfere with air traffic. Similarly, subsurface rights grant ownership of minerals and resources below your land, but these are generally limited to a reasonable depth and may be subject to Crown reservations. 7. What is trespass to land? Trespass to land occurs when someone enters your property without permission, regardless of intent or actual damage. This includes physically entering, placing objects, or causing harm to the property. 8. How are property transactions handled in British Columbia? British Columbia uses a land title system, which involves the execution of a contract of purchase and sale. The CPS is a legally binding document outlining the terms of the sale, including price, deposit, conditions, and dates. Upon successful completion of the CPS, ownership is formally transferred through registered forms that is filed with the Land Title and Survey Authority. The Torrent system guarantees the accuracy of the registered title, which provides a high level of ownership security and thus helps minimizes disputes about who is the true owner of a property.